thank you again to the Kampala Geopolitics to inviting me to join this conference and to Mr. Ambassador. It's, the theme that we're going to discuss is very interesting, and I'm sure we have a lot of students in the room, and sometimes you want a business and ethics go together. I'm sure you ask yourself this question. And when you hear the news, especially in some sectors like mining, oil and gas, some areas where you have conflict, you wonder what exactly is going on. And then government pass laws, and you're like, there's something wrong between business and ethics.
Despite the emerging popularity of the corporate social responsibility, or CSR concept, big businesses remain at the center of manifold accusations of human rights abuses. Often blamed for their greenwashing or pinkwashing practices, the need for international and national regulations seems to grow. In 2011, the United Nations developed the Guiding Principles on Business and Human Rights, which outlines the state's obligation to safeguard human rights from the negative effects of commercial activity, as well as the business's obligations to respect human rights and the imperative for both states and businesses to offer effective remedies when damage occurs. France has since developed a National Action Plan, or NAP, following the UN guidelines, but the extraterritorial capacity for regulation of such a framework remains quite limited. In June 2021, the German parliament passed a new law that will require large companies to conduct supply chain due diligence activities. The law, among others, requires these companies to identify, prevent, and address human rights and environmental abuses within their own and their direct suppliers' operations. In July 2021, the government of Uganda adopted its first National Action Plan on Business and Human Rights, providing a regulative framework for the private sector activities. How are new regulatory frameworks changing the nature of business? Are they capable of creating enough constraints for companies to adopt sustainable business practices that respect human rights? What indeed are mechanisms that could be envisioned both at the national and international levels to monitor practices and implement relevant measures?
So this is a very important conversation because we usually say, or you probably read in your books, that a successful company combines perfectly business, ethics, and human rights. This is the theory, but I guess it works when it's properly made and implemented. And I'm sure with all the great speakers we have this morning, we could leave this room after 1 hour and a half discussion with a clear mind, and with my friend next to me, I'm sure he will share a lot of great examples on how this works. And without further notice, let me make sure I have a line. My speakers that are not physically in this room. Is Makerere Suki online? Yes. I have my screen, but I don't see anyone. Oh, fantastic, fantastic. Okay, so let me welcome my speakers. Makerere Suki, French National Plan for OECD, Guidelines for Multinational Enterprises. Good morning, Makerere. I have online as well Angelo Izama, Director of Uganda Investment Authority. Good morning, Angelo.
Good morning, Didier.
Online as well, Gunter Rick Moncayo, Sub-Saharan Africa Policy Advisor on Economy and Trade, Department of European and International Cooperation of CAS. Good morning, Gunter.
Good morning from Brazil.
Fantastic. And right on my left, Andrew Biaruanga, Executive Director, Resource Right Africa. So welcome to you, everyone. Let me start with Maëlys. Maëlys, you've been working on a couple of principle guides and even French published passed a law regarding National Action Plan. Can you give us an overview of how ethics and business work together these days, especially based on the example you've been monitoring in Africa?
Thank you very much, Excellencies, Mr. Ambassadors, dear guests and dear public. I am very happy to join the panel this morning. I am speaking in Paris, where I am based, so sorry not to be with you in Kampala. I am working in the Ministry of Economy and Finance in France. I am Secretary General of the French National Contact Point for multinational guidelines, and also senior advisor on CSR issues. To address your questions, I would like to say that France is a very, very front-runner country in questions related to corporate social responsibility that we call today responsible business conduct, and on ethics issues. To respond to you in a few minutes, I could say that in France we have a very large smart mix of measures, going from hard law with laws and non-hard law mechanisms like initiatives and the NCP. And we have a broad range of measures from the due vigilance law I will describe in a few minutes. We have the National Action Plan on Business and Human Rights. The French NCP is very active to promote business and human rights, and is also a non-judicial mechanism to access to remedy. So that you may know that France was always a front-runner country on CSR politics. It began with non-financial reporting regulation, and a few years ago, after the Rana Plaza catastrophe, France adopted the very first law that made due diligence compulsory for large multinational companies. Due diligence is a methodology, it is a policy, it is a new ethics and a new paradigm for businesses. It means that the law requires very large French companies to assess risk of their own activities and through their supply chain, and they have to assess risk they may cause on human rights, on workers, on environment, on health and safety. The law requires French large multinational companies to adopt a due vigilance plan, to make it public, to implement it, and the plan has to entail 5 key measures to map the supply chain of the company globally, and they have to regularly control and monitor their supply chain, their subsidiaries. They have to take actions when they identify risks to mitigate them. It's a law for prevention, it's a law for changing behaviors of multinational. It is also calling for engagement with stakeholders. We have not only the law on due vigilance, we are very happy that Germany, that may speak in the panel, adopted a similar law very, very recently. We are very also happy that the European Union is preparing a European regulation to make mandatory due diligence for multinational companies. Together with the law, we use what we call soft law tools. Here comes the French NCP in the discussion. NCPs are national contact point for responsible business conduct. And we have the OECD, it's an international organization that adopted 50 years ago the OECD guidelines for multinational companies. It's a broad standard agreed by governments and multinational stakeholders. And in all governments adhering to the guidelines have to set up an NCP. And in France, our NCP is a multi-party body with trade unions, business organizations, and governments. And I am Secretary General of the NCP. NCP has a dual mandate. The first one is to promote standards for responsible business conduct. That is to say, respecting human rights, contributing to sustainable development, protecting the planet, protecting the people, acting with ethical behaviors. And the NCPs are also a non-judicial grievance mechanism. That is to say that complainant can raise a case that we call a complaint. They can submit a case to the NCP, and we have a mandate to help finding solution between the complainants and the company. We have an extraterritorial mandate. We work on international level, and you spoke about Africa. The French NCP has handled several cases dealing with French subsidiaries in Africa, notably in Cameroon, where we are working currently on sugarcane plantation of a French subsidiary, of a Cameroonese subsidiary of a French multinational. We have been working also in Cameroon on palm oil. These cases are about impacts on human rights, environment, and disclosure of information. We have been requested by local NGOs and a collective group of people living surrounding the plantations. We are working on a case about gas exploitation in Tunisia, where here also the NCP was requested by local and international NGOs. NCPs can work also with trade unions. We got a lot of cases coming from trade unions in the USA, in Europe, in Cambodia, for example. And the NCP is a body, is an access to remedy institution where we will, when we receive a specific instance, we have to look if it is admissible, and then we offer good offices to the parties. It's a door open for dialogue to help finding solutions. It happens often that at the end of the dialogue processes, we don't have an agreement among the parties about what the due diligence is about. There is no agreement about a social conflict or measures that we consider sufficient to implement these guidelines correctly. In this case, the NCP will issue a statement, because one key aspect of this access to remedy system, it is that it is making public its decisions. So the French NCP has its website on the DigiTreasury. It's pcnfrance.fr, where you can find all our final decisions and admissibility decisions. And the decision is where the NCP explains what the case is about, the issues raised, it describes the procedures that we followed, and we give the analysis of the implementation of these standards for good corporate behaviors. And this transparency is key, because NCP have to be accessible, visible, transparent, and we have to make public our works so that all the multinational companies can use our analysis to modify or improve their practices. Now we do the best we can to promote and be there to address questions raised by stakeholders, but we know that the road is still very long. We hear that there are still many problems in globalization, in mining, extractive industry, agriculture sector, like you mentioned, dear Chair. This is why at the OECD, all NCPs will work together to issue sectoral guidances and to set up sectoral platforms where we gather unions, NGOs, governments, workers, to look at the sectors and step by step strive to improve and make these standards better known. And it is very important to have in mind that both the French law and these international standards like the UNGPs, the United Nations Guidelines for Business and Human Rights, the OECD guidelines, ILO international conventions, through the NCP, all these standards, they apply abroad, so that French multinational companies, when they are acting internationally, they should respect all of these standards all over the world. And this is where NCPs are very useful, because we can be requested to look at a case and explain what's going on there. So access to remedy is one option that we need to improve the situation. And it's also good that foreign governments, they use the UNGPs, they use the guidelines to ask international companies to respect human rights also in their countries, as we don't have human rights here and human rights abroad. Human rights, the planet, the people, it's the same all over the world, and this is what we are working for. Of course, I can give you more details on many aspects if you have other questions, but I think it's very good to hear also the other panelists.
Thank you very much, Miley Suke. I think you've mentioned so many examples, and there seems to be a framework that is being put in place to address those issues. And I will come back to you later on. Let me give the floor to Gunther. Gunther, Germany just passed a law. Of course, you introduced yourself by, but my question is, why did we have to wait so long before passing such law? But I'll give you the floor for your presentation first. And thank you again for being with us.
Yeah, thank you very much. Yeah, well, the question is correct. Why did it take so long? Because the German Parliament, the German Bundestag, passed the due diligence legislation just recently this summer. In Germany, it's usually referred as to the Supply Chain Act. But the debate around the responsibilities for businesses in the context of human rights goes back, well, at least to, and Miley's mentioned already, the event at Rasa Plaza in 2013. So this was maybe the starting point where the responsibility for businesses in regard of human rights came onto the public agenda. So it was already discussed, and we can go back even more if we look at 20 years ago. Or let me start differently. It's till 2002, it was possible for German companies to deduct bribes, the expenses they had from bribes abroad from taxes. So it was a whole different mindset just 20 years ago. It's not so long ago, right? So there was a strong differentiation between us here, the responsibility a company has within the country, and the things that happen abroad. The things that happen abroad, roughly for the legislator, didn't play a bigger role. So that changed like 20 years ago when first in the tax law they eliminated the possibility to deduct bribes paid abroad and made it illegal to pay bribes even abroad. And then we had a discussion since then that took off when the images of Rasa Plaza shocked the German public. So in 2016, the German Parliament agreed on a national action plan for business and human rights, and in this national action plan, the government laid down the company's responsibility to respect human rights in a fixed framework for the first time. And in this action plan, the government expressed the expectation that the companies will respect this responsibility in a voluntary way. So in two occasions, the government made a survey to evaluate whether the companies are fulfilling their responsibilities or not. And the result was that the companies didn't know what was happening in their supply chain. There were no mechanisms in force. There were no knowledge about how the suppliers respect human rights in their production line. So then the debate started on the need for a hard legislation, as Maïlis calls it in her input. And that's where the debate about the due diligence legislation really started. So it's a very long process. You're right. It took very long, and now the act is there, but it will come into force just next year, the year after that, 2023. So the businesses have a lot of time now to prepare for this, and it only affects companies with 3,000 employed persons. So this is roughly 900 enterprises in Germany that are covered by this law. I'm more than happy to go more into detail in the course of the discussion, but let me just say at this moment that of course there is a strong debate on whether this legislation is the right way to solve the problem that all of us agree on. So neither the German companies, nor the German consumers, nor the legislator want human rights violation, be it here, be it anywhere else. But there are some critiques, and the critiques, they focus mainly on focus mainly on the question whether the Supply Chain Act, so the due diligence legislation in Germany, is capable of solving the problem or of being part of the solution, because we have to see that Germany's economic influence in Africa is very, very limited. The investment of German companies is, if you take out the northern African countries and if you take out South Africa, there is hardly any investment. The German investment volume in Malta, a country with roughly over 500,000 people living there, is larger than in the 48 countries of sub-Saharan Africa. Can there be any positive effect if the influence of the German companies is so low? And the other strong critique that has been raised in Germany is that the legislation somehow stands in the way of the realignment of German Africa policy, because the German Africa policy has towards the German African policy puts an emphasis nowadays on private investment in Africa. So the idea is to foster economic activity of African firms in Africa, but also of German firms in Africa. So the question is whether this legislation hinders German companies in investing in Africa. And why could it hinder German companies investing in Africa? Not because they want to do human rights violation and they feel that they now they are not allowed anymore, but because it puts a high legal risk on the firms. It's a new law. There are some nations, so nobody knows how the government and how the courts will deal with violations of the law or with claims, because the law, for example, also introduces a right for workers abroad to sue German companies in Germany for responsibility. And the question is, how far goes this responsibility? Because the law itself applies to all levels of suppliers. So not only first level suppliers, also other levels of suppliers. And it's difficult for a German company to even know the supply chain as a whole in some other countries. But of course, we can talk more about the critiques and the other points that are being raised if there's an interest on your side. But of course, there's also a huge portion in the public that...
Thank you very much, Gunther. I think it gives us a good perspective from the German side, and I'll come back to you with the critics. Let me move to Angelo Izama. Angelo, what we've been hearing from Paris, from Germany, I guess resonates in your mind, because Uganda as well has passed a national action plan. And I guess if Germany, France, or European countries are passing these laws to, of course, make sure the companies respect human rights when they operate in Africa, it probably means on the African side, we need some vigorous responses when those companies don't respect the laws and don't respect human rights. What is your perspective on that, especially from Uganda? And the whole judiciary system, how does it respond to those new requirements?
Well, thank you, Didier, and I thank everyone who is attending this particular session of Kampala Geopolitics. I would like to start by saying I bring you greetings from the Uganda Investment Authority, and my chairman, who was initially listed as the participant here, the chairman of the board, Mr. Morrison Rwakakamba, he's actually out attending to an investment matter in the agro sector in Western Uganda. And maybe I can start over there, because the question you're raising about forward-facing European countries in terms of their approach to business and human rights is not very different from Uganda itself. Take, for example, our recent history with oil and gas. Uganda is very unique in a sense that if you look across the African continent, and I'll tell you where I'm going with this, most countries that discovered large deposits of fossil fuels immediately went to the market on an average of between 3 to 5 years. Uganda discovered oil in 2006. We are just on the cusp of going to the market. That means that we have had in excess of nearly 15 years, of confronting the challenges that come with oil and gas exploitation. And if you look closely, what that has done for us is that it has allowed Uganda to prepare forward-facing legislation, to prepare institutions that can govern this new environment, which integrates best practices around the world within a local context. And specifically with regard to things to do with direct human rights, the activities you see now that have to do with land compensation, resettlement of people who are affected by large oil projects, have included a mix of really high standards, which are the result of what companies, particularly the oil and the international oil corporations, are expected to do by their shareholders and by the rules that govern them, and our own assessment of our needs and the needs of our own people. So the current environment, I think, for most sectors, is such that Uganda is in a position to begin, this journey of economic transformation with the best rules in mind. Now, that said, we have a very ambitious agenda. I know that under the National Action Plan that you referred to, the Uganda Investment Authority is one of those government institutions that are part of the institutional architecture to see this action plan implemented. But one of the central things we're doing is essentially trying to build 25 industrial parks, to drive industrialization. The good news about that is this is a planned process. It's a forward-looking process. It is planned, It means that, first of all, companies can be located in specific areas and the rules applied to them. I would be in the same position that Gunther had raised with regard to the concern of German companies. It's a very dense environment to operate in. Companies may feel restricted. Personally, I prefer less regulation than more. I think that public knowledge is a better investment in matters to do with human rights and business. But the current situation for Uganda and most of sub-Saharan Africa is that the growth demands on our population have coincided with a historic demographic event. In other words, we have got a very large young population that is also fairly educated, that is mobile, and that has put governments under pressure to provide as many jobs with dignity as possible within a very short period. Now, the issues that are raised from that grand effort include, traditional things like, workplace safety, consumer protection, confidentiality in the case of, this techno-driven environment that we are in that involves the use of technology that's intrusive for the most part, and then complex questions, which I guess my panelists here, the fellow panelists and the audience might want to address themselves to. Complex questions such as the one that is being addressed right now with regard to what is the place, what is the role, what is the role of this generation of human beings with regard to pollution of the planet? That's a major ethical issue that is being raised here. The other question for a lot of Africa that is relying on debt-driven industrialization is, if you take on too much debt that binds generations in the future, shouldn't we be asking if freedom from debt for future generations is not a human right by itself? So what obligations do we owe to future generations to make sure that they're not saddled with debt that we have incurred now in the process of driving growth? So that's the complex landscape. But in terms really of what we are prepared to do, first, we are interacting right now with the recently passed National Action Plan, and we shall join the other government institutions and work in coordination with them to try and platform what has been decided as is adequate. And finally, I must tell you that, of course, here at Kampala Geopolitics, we're dealing with not just African issues, but global issues, as you can see from the panel. Matters of dignity and work for Black people and as an African nation are really, it doesn't appear as if we speak about it all the time, but they are really close to our hearts. Why? Because, anytime you talk about labor exploitation and Black people, it raises historical issues with regard to the advent of industrialization, imperial capital, and its effects on Africa in particular. So these are matters that are of interest institutionally and for the people of Uganda, obviously, and for young people. And I want to end by saying that the practical work, I think, begins with embracing the National Action Plan and then, proceeding in a diligent manner to try and make these rules work for everybody. Thank you.
Thank you very much, Angelo. Human rights critical. Andrew Yauranga, I think you probably one of the best witnesses. We've been hearing, let me say, the theory. You on the ground. Is that real? Do you witness those practices on the ground, or is it just purely theoretical?
Thank you very much, Didier. I'm really delighted to be part of Kampala Geopolitics, to be here for the first time, and for sharing this platform with eminent panelists and my colleague like Anjali Zama, whom we have really, in the past, before he climbed the ladders, were in the trenches in Albert and Graben, trying to unearth some of the questions which we are talking about in the oil and gas sector. First of all, is to note that Uganda's move to have the National Action Plan, it was not a homegrown area. It came out of the Universal Periodic Review in 2016, a recommendation from Norway that Uganda should have a national action plan. We applaud government of Uganda accepted, and the journey to have the national action plan kicked forward. So on 28th October, just last month, indeed, government of Uganda launched the national action plan amidst some observations in terms of how wide consultative the process was, because we note that the people we are legislating about or talking about, the business entities, were not all that consulted or involved in this process. That we take note of that. But also we take note that the National Action Plan is a soft law, and we don't think that it's going to be the alpha and omega to have the issues that we've been monitoring as non-state actors resolved. So coming to your point, as Resource Rights Africa, where I serve, we've been on the ground in the mining, but also in the oil and gas sector, witnessing quite a number of issues that you ask me whether they are there. Indeed, quite a number of human rights violations are taking place. Like Angelo noted, the aspect of land acquisition. We note that the Uganda Investment Authority really is trying hard, and it's level-based, and everybody wants that, to have quite a number of investors coming into the country. But the National Action Plan, which comes again from the UN Guiding Principles on Business and Human Rights, one of the cardinal principles is free, prior, and informed consent. But we take note that most of the multinational corporations that are coming in are not living to that principle. So you have community members who are displaced of their customary lands in the hands of the quest for investment, the quest for foreign direct investment, and the people are yearning for solutions. They are trying to look where can they get remedy when these violations take place. Because the challenge most MNCs are doing when they come on the ground and find empty land, for example, in Karamoja, they think that nobody owns that land. This is customary land, because land there is demarcated according to settlements, it's demarcated according to grazing lands, and of course, maybe cultivation for, short-term crops. Take an example again in the same region. I'm talking about Karamoja. 90% of the land in Karamoja is under government land in the form of game parks, forest reserves, institutional lands like schools and hospitals. So people are just living on 10% of the land. And now multinational corporations are coming in and squeezing the general population, the indigenous communities, they are struggling for the 10% of the land. And that is a big, big worry. So Angelo is talking about industrial parks. Where are they going to be set up? Are people consulted? Are people compensated? Is the compensation adequate? In any case, how do we define the adequacy? The terminology that this is adequate compensation? Because we've seen a lot of challenges on who defines that this compensation is adequate. But surface rates compensations, for example, in the mining sector, by law in Uganda, we are supposed to compensate the landowners. But we've seen quite a number of multinational corporations really not living to that standard. We've seen child labor in the mines. Children who are supposed to be in school, studying, learning, just like the rest of the children, they are hauled up in the mines. And women are equally shortchanged. Sexual and gender-based violence in these mining sites is yet another challenge that we are seeing on the ground. And then we are wondering whether the remedy is within the National Action Plan, which is just a soft law, and no much expectation from many actors as far as the National Action Plan is concerned. Yes, it's a good step. We've implemented the recommendation from the UPR, but is it, will it bite the multinational corporations? Perhaps the future of some of us lies in championing the campaign around the UN binding treaty on multinational corporations and other businesses, such that we have a uniform law that cuts across all states and nations to ensure that multinational corporations are held accountable. When you look at the national action plans, many countries have taken different paths to come up with national action plans on business and human rights. In Uganda, it has been a struggle, by the way, even to have a standalone national action plan. Initially, it was to be embedded within the national action plan on human rights until some of us made noise and said, let's have a standalone national action plan. You take a country like France, some of them have decided to just have letters and they call those national action plans on business and human rights. Others are not comprehensive. I don't know, the one of Germany, for example, I think if you take a look, some have taken, like the US, just a template. So Uganda's national action plan, yes, we can say it's much better than the one of US and Germany. It's comprehensive, touching on labor issues, touching on service delivery, touching on environment, touching on quite a number of areas. But again, we wonder whether there is that spirit to make it bite to the multinational corporations, because we know that these are quite bigger than what we are talking about. So these are some of the concerns that we get from the ground, and much as the National Action Plan has come in, but I think the future lies in having a binding legislation that cuts across nations, not just having one in Germany, another one in France, and then those, when it comes to the supply chain, they don't bite. So let's have a binding treaty on multinational corporations. Perhaps we can have access to remedy for the communities that are impacted by business operations.
Thank you so much, Andrew, for bringing this reality into the conversation. And my colleagues online, Melis, are you there?
Yes, I am here.
Okay, Melis, from what Andrew just said, tangible examples that it's not working. So from your office in Paris, where you pass laws, you monitor, you put the right probably framework to the reality, how can you address precisely the issues Andrew just mentioned? The role of the government, for instance, in Europe, in Paris? Is it a sanction? I mean, how do you react to that?
I'm very happy, first of all, to listen to him and to the co-panelists. And he raised key issues and a huge challenge. Yes, discussions are ongoing at the United Nations about a project of what is called a legally binding instrument on business and human rights. It's a long journey. We have adopted the French law after the Rana Plaza catastrophe 5 years ago. We adopted the law in France. But our purpose was to bear it, to promote it, to engage other countries to follow the movement for more responsible global supply chains and for multinational taking care of the stakeholder engagement before they engage in a new project, to take care about the impact of their activities outside and inside the corporate. Now we have engaged a lot of promotional efforts as NCP and as the government into the European Union institutions. As Europeans, we believe that our European Union is a very good level to go forward with a mandatory due diligence regulation. Why do we consider EU the right level? Many multinational companies that are sourcing mineral in Africa, agriculture in Africa, that are making the goods being manufactured in Asia, where the raw materials are coming from Africa, they go to Asia, and then they go back to Europe. We are supporting both the government and civil society is supporting or is pushing the European Commission to announce as soon as possible a draft regulation on mandatory due diligence. The EU is also at sector level. We have draft regulation for battery. We are expecting a draft regulation to fight deforestation. These are tools to improve due diligence and to make companies aware that they have to ask questions on their supply chains. They have to be careful. And at the NCP, to answer also issues that were raised by my co-panelists, the issues that we see in our cases, in the specific instances, it is about stakeholder engagement. How do a company engage with surrounding people? How is it making sure that there is a social content to the project? How is employment there? How to promote local employment? We see in cases about oil, gas, palm oil, wind farm project, we see the issues of the pollution of environment. We see issues about land. It's the use of lands. It's the issue of how to engage with indigenous people to make sure that they are aware of a project, that they can have a voice. And all these topics are difficult because sometimes and very often we have a different level of expectation from the OECD guidelines on business human rights and RBC, responsible business conduct, and local laws. We see in our concrete cases, like in Mexico, for example, where we may have different understandings. We have the government that is pursuing an administrative consultation of indigenous people. At the same time, we have expectation that the company will do it. So we need to combine hard laws, soft laws, responsibility of multinational with the purpose of doing better and accompanying companies for change. Now we understand that dialogue is not always enough. We see that we try to promote good corporate behaviors, but finally we needed the law. And there the judge may step in. And we have several cases below the French due vigilance law that are currently being handled by judges in Paris. One case is linked with corporate behavior in Brazil. One is linked with corporate behavior in Mexico. One is linked with corporate behavior in Uganda, for example. So this world of extraterritoriality or international leverage or business and human rights all over the planet, it is needed to go hand in hand with the smart mix of measures. Hard law is needed, soft law tools are needed, access to remedy is key, and it is what, as a government, we are pushing for, to have several doors open to address problems, because the discussion on a new policy is important as the access for remedy is important. So it's not only one aspect, there are many aspects. And this is not easy to navigate, but we believe it is very important that the European Union came with an ambitious draft regulation on due diligence to have an international level that will be used by foreign governments and foreign civil societies and trade unions to require companies to have the good responsible business conduct. And we know that for our companies, it is also a very positive argument when they do business. When you behave correctly, when you can demonstrate that you engage with the workers, that you have social dialogue in your company, that you are careful about the environment, that you mitigate risk through actions plan. It's a way to attract financing. You have a better access to financing. You have a better trust with local governments. We have less issues or cases with local population. So it's a win-win solution. So this need to change the policy of the company to a more responsible company. It's something that as a government we are pushing with laws and with NCP, but it is also from the company point of view a very powerful tool for the business itself and for the competitiveness, and also to attract workers in your company. My co-panelists mentioned the youth. And you know that the young people today, when they enter into a company, they need a purpose, they need an objective. They want to share something for the planet and for the people. So this policy is not only on paper, it needs to turn into reality.
Thank you very much, Maëlys. Let me turn to Gunther. Is it a more moral approach? I mean, why suddenly European countries or developed countries suddenly realize that the large corporations that create jobs in those countries, that generate revenue, the wealth of those countries, suddenly realize that they should apply ethics in business? In Africa, for instance, what happened, and what kind of sanction mechanism do you have to make sure this law are probably enforced?
Why is it now? Well, society and also politics is something that keeps constantly learning, and we are evolving. That's how it works. We try to do it better every time. So of course the critique is valid to say why did it take so long to take these problems into account? But the positive side is that we are taking it now into account. And I totally agree on Maëlys that the European regulation would be a huge step forward. In a single market, it makes no sense to have different national regulations because on the one hand it creates a sort of unfair competition within the European Union if you have different national regulations. And on the other hand, I mentioned the limited influence of Germany as a single country, but of course the European Union as a whole has a much bigger influence. What measures can be taken? Andrew mentioned that we need legislations that we need to make it bite, right? And he's right. We have fines in the German legislation that go up to 1 million euros and above. And what is maybe more important, or maybe hurts the enterprises even more, is that if a company does not fulfill its obligations from the due diligence legislation, they can be excluded from public procurement processes for up to 3 years. And we all know that in the public procurement processes, there is a reasonable amount of money to make, so the companies will not want to be excluded from that. But an important thing for me, and also some of the other panelists touched this issue in their interventions, is that we must not forget that the responsibility for the enforcement of the laws is the one of the governments, of the local governments, right? So usually we have a quite sophisticated legislation, but often the enforcement is a problem. And I hope that this question, so the inclusion of social and environmental standards in supply chains, I hope that this will play a bigger role in government consultations, for example, between European governments and African governments. And the ultimate goal, in my perspective, should be to strengthen democracy and the rule of law. Because human rights, and this shows the experience from a lot of cases, human rights can only flourish fully under stable democratic conditions and only under the premise of the rule of law. So the strengthening of democracy and the strengthening of the rule of law in any country, it must become a central element of any initiative. And the last aspect that I want to mention here is that we as Germans and Europeans must continue to focus on how to strengthen incentives for the engagement of our companies in Africa, because what we need is to foster the economic development in Africa. Africa needs jobs happen if there is a significant economic activity also from foreign companies, not only, but also from foreign companies. So this would be my two main points: strengthen democracy and rule of law, because this will strengthen the rule of the human rights situation in the countries, and to have a look on the investment environment in order to foster economic development.
Gunther, have you seen some improvement in how German companies behave since you passed the law, since you've tried to put in place this kind of framework? How do you monitor the progress concretely?
The progress, well, as you know, the legislation is quite new, so there is not so many experience. Until now, we are now in the phase where the companies have time to build up their mechanisms, to build up their reporting system, and there is a government agency, a federal government agency that is supposed to overview this process, these mechanisms, to overview the reporting and the due diligence mechanisms of the companies. And sadly, we will just see until 2023, when it comes ultimately into force, how this government agency will deal with the results presented. And that's part of the critique, right? That it's like a little bit of an unclear situation, and that sadly we have to wait until 2023. Maybe would be an opportunity to put this back on a subsequent geopolitics conference to see, okay, where do we came from, where are we standing, and what needs to be done in the next years.
Mm-hmm. Thank you, Gunther. Angelo, we probably have some issues on the ground, you know, and Andrew, explained it perfectly. What is our own responsibility in tackling those issues related to child labor, sex trafficking, violating of laws? I mean, the rule of laws, it seems like we have issues to implement them and make sure they're enforced. Do you think it's because we need a more robust judiciary system? And I was talking to Andrew before we started the panel. Typically, African governments are willing to attract investors, to attract multinationals. So it's like from time to time, they don't really apply the laws as it should be because they want those companies to come and invest. So how do you address those issues and make sure, especially in Uganda, with oil and gas exploration that is about to start, how can you prevent those typical issues that Andrew mentioned before? What needs to be done? Because on the European side, it seems like they're doing their job. On our side, what needs to be done?
Well, Didier, like I said, I'm a huge believer in the power of public knowledge. In fact, Andrew mentioned that me and him go back a long way, but I'm sure some of the people in your audience remember a little experiment that I did in 2008, just when the oil sector began, where me and a colleague went to court and said, well, you know, they have signed these agreements, let us see them, make them more public. And there was a moment in the next 4 years where, as Ugandans, we were questioning agreement project. This experiment is about public knowledge. It's important that we don't repeat the mistakes that happened elsewhere in the world. And you cannot do that simply by legislation. You need to get the public behind it. And if you've been tracking these issues, you know, Uganda's, the public response, what we used to talk about, the high unrealistic expectations about what this oil and gas sector can do are some of the lowest in Africa. In other words, we are really coexisting with oil and gas, and it allows for institutions that are responsible to engage practically with the challenges that Andrew mentioned, things around, for example, land resettlement and compensation and all those things. Look, and this is for Mr. Biarahanga. We are in the trenches together. I know as the investment authority, we facilitate investment promotion because we want investors to come and be a part of our growth plans. And of course, Gunther, I don't know if you read in the news, but we hosted a large German delegation of investors just this last week. So Uganda is essentially open.
Andrew, I mean, this is serious business. You know, when you have large corporations investing billions of dollars, and then suddenly you're trying to make sure they respect the laws, they don't do any kind of trafficking, bribes. I guess you receive some threats from time to time. And how, as a civil society, I mean, it's like David versus Goliath. Do you see what I mean? So how do you manage to survive those environments where you have large corporations trying to find their way to do this business and people like you trying to protect, basically, population's interest, child interest? How do you deal with that? Because, I mean, in terms of your capacity, they are quite limited.
Okay, thanks, Didier. I think we need first to appreciate that as human rights defenders, whether as organizations or individual human rights defenders, indeed there are threats that come along with the work that we do. However, the aspect of attribution, I think we have to look at who is culpable in the threats. I think it has been more to do with our national governments as opposed to MNCs at the moment. So it's not that you will see a multinational corporation coming to you, but as you know, most of our governments actually are working hand in hand with the multinational corporations because of the real reasons why Angelo was talking about. We need foreign direct investment. So any effort geared towards raising some of the critical issues is mirrored in a certain perspective, and that creates some of us trouble at some point. But also it goes with the lack of understanding, just like Angelo mentioned, lack of information. Because if a multinational corporation is coming to invest in a fragile environment, how much do they know about that community where they are going to invest? So sometimes it's a lack of knowledge to understand that this community has been living in this way. This is the way of life. This is how they manage their land tenure system. This is how they manage their business. So a multinational corporation comes in with insufficient information and knowledge and sinks in billions and billions of money, and then the people start to feel bad about that investment. So human rights defenders are key if we are talking about the National Action Plan. Actually, for the Ugandan's case, we wonder why the National Action Plan doesn't talk much about the contribution or the protection of human rights defenders, because this is a key component that should be well highlighted in the National Action Plan on business and human rights, because we know land, environment, and river and water human rights defenders are at a threat when it comes to raising some of the issues standing with the communities. So the threats, in most cases, of course, you cannot talk about business and human rights without talking about civic space. So we've seen across the board in many countries, natural resource-rich countries, that where you are having an increase in investments, but also the civic space is equally shrinking. And it comes in all sorts of forms. Some of it is in legislation, some of it is physical, and some of it is in certain other tactics that you may not understand. So that is a big challenge. Currently here, we are dealing with how do we ensure that all of us are for investment. We understand that. We appreciate that, because we need this money for service delivery. But at the end of the day, we are also saying, hey, look, there are communities who need their rights also to be respected. If there is a violation, can they access remedy? Are those those institutions within the communities where they have to seek remedy? Take an example for those who know Uganda, Karamoja. To access court services, you have to go to Soroti, and this is hundreds of kilometers away from the mining communities down there. So these are the challenges that we are grappling with as human rights defenders. But to mitigate all this is we are having dialogue. We are open to dialogue. And my stakeholder dialogues are key when issues arise, whereby companies are on the table, civil society actors are on the table, and government officials are on the table, such that these issues, once they are raised, as my fellow panelists noted, sometimes it's lack of information, because when our government representatives go to the Human Rights Council in Geneva and agree to these norms and standards, how much of that trickles down to back home to ensure that the enforcement team on the ground understand that this is what our government has agreed upon. Sometimes it's not there. So even as we come to have the National Action Plan on Business and Human Rights, it should not remain in the capital. It should be taken to the business actors on the ground, such that it is mainstreamed within the operations of these companies. Because many times you'll go on the websites of these companies. Yes, there are other bigger multinational corporations who have these standards in the capitals, in Paris and elsewhere, but you find that on the ground, how much of the policies of these companies are known by these workers on the ground. So we find a disconnect between what is there and what the people on the ground know, and how also they interact with the local environment, because the context keeps changing, and that is key. So the people you're interacting with on the ground may not understand or buy into the institutional setup or understanding of what the institution has brought up. And this cuts across between the companies themselves, we've realized this, but also within the government. You realize that the local authorities may not understand what the central government wants to put in place.
Thank you, Andrew. We were supposed to have 1 hour and a half discussion, but I've just been told that we have 5 minutes left. Is that correct? One question here, one here, and I'll go back to the speakers. Gentlemen over there, can you have the mic? Yeah.
Thank you so much. I am Kennedy, a lawyer and a human rights defender. My issue comes with the social corporate responsibility with these investors. I would like to talk about a painful example of the Chinese that are busy constructing roads. You find that they're impregnating a lot of girls in the community, and they're leaving them, the kids fatherless. They deny the pregnancy. When they're done with the contract, they leave. Nothing is being done about it. What is this doing? This is affecting our culture. When you're an investor, what are you looking? Because culture is a right. So you're coming to deteriorate the rights of the people in the society by impregnating and leaving the children fatherless. Secondly, there are aspects on environment, destruction of environment, the pollutions that they're doing, how far we see our Lake Victoria being, there are a lot of dumpings taking place, the forests being cut down, and so forth. So those are the human rights issues that I would like the person with the Uganda Investment Authority to actually address, because it's really a pain to the nerve to the young generation.
Thank you, Kennedy. Angelo, are you in line? Angelo, I don't know if you have heard the question.
I had the question.
Fantastic.
My answer is that, we expect the companies we invite to invest in Uganda to respect their international obligations and to respect local laws. And like I said earlier, it's really the job of everyone, including the Ugandan judiciary, local governments, where these investments are, to ensure that there is respect for local laws, and the companies are held to account for their obligations. There is no place in what we do that says we should sacrifice the dignity of workers or communities for investment. It's not one or the other.
Typically, Angelo, were you aware of this case or not at all?
Yes, I'm aware. They have actually been following, as you know, my background is as a journalist, so I've been following some of the stories around, certain communities seeing a very large number of mixed-race children in northern Uganda, around one of the big projects there. To my knowledge, this hasn't been addressed by the government agencies that are responsible for this sort of thing. It's outside the purview of the investment authority. But like I said, there are rules that govern the behavior and conduct of foreign workers when they are in Uganda, and these rules must be absolutely followed.
Good morning. My name is Juliana Kayaga Seremba from Strategic Engagement Limited, and my question is around extending the dialogue. We are having a lot of conversations around policy at a country level, and yet the people that are going to implement this are the people in the business fraternity. So it would be interesting to understand what are some of the initiatives that are being taken to onboard, create awareness, buy-in, and then get championing of these issues of business and human rights by the private sector and by the business leaders that we are having across the globe, so that it is not overhead driven, but it is actually being pushed by the people who are in control of the policies and practices at the private sector level. Thank you so much.
Thank you, Juliana. Andrew, how can you address what Juliana just said, which is quite important?
Yeah, I think the opportunity lies in working with the business associations, which are really quite there in this country and globally. For example, most businesses have signed up to the UN Global Compact, and these are big businesses like Coca-Cola, Lafarge, and others. So this is a platform that we can utilize to ensure that this information reaches out to them. Of course, at local level for the Ugandan local content, we have the Casitas of this world, we have Uganda Manufacturers Association, and of course, all these spaces that we can create for the business community. The only thing is we need to structure the language differently, because from the field where I come from, civil society, sometimes most of the language used is not palatable to the private sector. They don't want to hear certain things in a certain manner. So we can have safer spaces where the business community are able to articulate and also listen to this. And as Resourceless Africa, for example, we've been working with the Nordic business community here in Uganda, working with the Danish embassy to ensure that the people listen and appreciate the kind of information which we are talking about today here at Kampala Geopolitics.
How can you involve the youth, for instance? You know, youth, they are all over the country. What could be the role in this whole monitoring process and making sure things are properly done?
I think Uganda, we have the youngest population and quite an enterprising population at that. Most Ugandans actually are initiating businesses, and now if there is one thing that we've gotten out of COVID moment, it is that people have become more sharper in initiating new businesses. So, and these are mainly the youth. And this is where we need to take the conversation of business as human rights and digitalization. And where the youth have really come in to be innovators and come up with the new innovations to make a living, but also to solve some of the underpinning challenges that we've been having as a country. So there is value in engaging the youth. The only worry is, have they been engaged much in terms, for example, of designing some of these frameworks, like the National Action Plan on Business and Human Rights? I think your guess is as good as mine.
Thank you, Andrew. Madam, right here.
Oh, I'm Judith Muvara.
Judy.
Judith Muvara. My question is addressed to Angelo from Uganda Investment Authority. Following the study done by Ministry of Finance, over 21 big companies, foreign companies, are exiting the country. The most recent being AfriCell, Game Stores, and ShopRite. And we have very many more, Nakumat, Uchumi, all these people have been, companies, very big companies have been exiting the country. And my worry is, and these are companies that actually employ like 70% of our Ugandans, meaning a lot of people lose jobs. So my question to Mr. Angelo is, what is the problem? Why are these companies exiting? And what is the best way to address the issue? When we talk to these companies, most especially ShopRite and Uchumi Nakumat, they told us that there's a problem with competition where they have stores, they have supermarkets, but our local people in the informal sector come to the verandas and sell the very products sold in the supermarket. So how, I think I would address Mr. Angelo to fast track the competition bill to be enacted in Parliament as a recommendation. Thank you very much.
Thank you. Angelo, are you there?
Yes, I am.
How do you respond to that?
Thank you, Judith. It is true we have a process at the Investment Authority try and understand how we can retain these large multinational corporations, and also how we can integrate their experience into better policies to support their businesses. Some of them have, as you correctly said, are dealing with intense competition. Competition is not a bad thing; it's a good thing, actually. And so they have made plans, to move their businesses in other parts of the continent. Look, in as much as there are businesses that are leaving the country, you must also know that Uganda is a net destination for foreign direct investment. Recently, me and my colleagues, we camped here at the Dubai Expo at the Opportunity Village. Our intention is to bring at least $5 billion worth of investment in the period of the Expo, which is a 6-month event, but also not just attract just investment per se, but locate that investment in areas where young people are most involved. The policy right now is, of course, to support import substitution. In other words, we want businesses to come and start producing goods that in Uganda rather than import. We also support through an incentive regime training and skills transfer. The Uganda Investment Authority is particularly interested in businesses that are able to bring new technology and skills to young people that we can retain in the country. And the third aspect of our approach is to do quality production for export. Our sense is that the plans we have for growth will survive the business cycle. It's a difficult environment right now for global corporations, as everyone knows, because of the coronavirus. All countries are targeting investment, including, of course, countries like France and Germany. They are also dealing with their own employment issues. Uganda is not an island in that global village, but we'll ensure that our environment is as attractive as possible. As young people, I want to tell Judith, you, apart from taking an interest, as you have done, on what is going on with the institutions that represent your interests, you understand that we are acting with confidence and with competence. And I think that is what the current generation of Ugandans expect out of our efforts. Thank you.
Let me give 1 minute to each of the panelists to give me his or her takeaway. Let me start with Maëlys. Are you online, Maëlys, for 1 minute takeaway?
Thank you. I would say first, thank you so much for inviting me to this very, very interesting conference. And let's try to join forces to improve corporate social responsibility, responsible business conduct. And I really believe that multi-stakeholder dialogue and combining hard law, soft law, access to justice, access to NCPs, all of this together, the smart mix measures is a way to go forward and to make the new paradigm of globalization more human, more social, and more respectful of the environment. I would be happy to continue the conversation we have, but by lack of time, I will give the floor back to my co-panelists. Thank you so much, and bye-bye, Kampala.
Thank you very much, Maëlys. Okay, let me give the floor to Gunther. 1 minute.
Yeah, thank you very much. I will just end by saying that the question from the audience concerning the Chinese investment, it showed very clearly, from my view, that the solution of the human rights issues cannot rely on German legislation or even European legislation. Of course, the framework on the ground, the framework in Uganda has to be in the center of attention. And I'm very happy to take away from this discussion that the National Action Plan in Uganda is very keen on tackle these issues, that the discussion is vivid, the discussion is going on, and I just want to encourage you all to keep this discussion vivid and strong, and to make sure that businesses fulfill their responsibility that they have. Be it a foreign investor from Europe, be it a foreign investor from China, or be it a local company, they all have to take up their responsibility. And I hope that we continue this discussion because it's very important. Thank you.
Thank you very much, Gunther Moncayo. Let me give the floor to Angelo Izama for 1 minute conclusion.
Well, thank you, Didier, and thank you everyone for including us in this conversation. As I said and on behalf of my chairman Morrison and my colleagues at the Investment Authority, I think it's quite clear that people come first. when it comes to this kind of work. We put people at the center of investment decisions. And to that extent, we appreciate any opportunity to educate ourselves, to work with other institutions, other Ugandans, and other partners from elsewhere to ensure that when it comes to the business of growing investment, providing jobs, and so on and so forth, that there is dignity and respect for our Ugandan laws and Ugandan traditions. Thank you very much.
Thank you, Andrew Zama. Last but not least, Andrew Yaruwanga.
Thank you very much, Didier. I would like to congratulate the government of Uganda for having adopted the National Action Plan on Business and Human Rights, becoming the second country in Africa and the 30th in the entire world. So that is a milestone that the government of Uganda has made. However, there is need now to move a step further and ensure that, for example, the bilateral treaties that my colleague Angela Zam is talking about, we have signed in the Dubai Expo and elsewhere, they need to be now brought into tandem with the National Action Plan on Business and Human Rights, because we've realized that these are not talking the same language. Equally, the language that is being used in some of these soft laws that have been initiated in different countries, the language need to change, need to be harmonized. For example, the use of abuse vis-a-vis violations. What do we mean by this? So all this needs to be done. Finally, I think there is need to ensure that we have less expectation from national governments when it comes to enforcement of human rights violations in the business or in the corporate sector. And as such, we need to move again to a binding treaty such that we are able to have a framework that cuts across borders, not just having a Ugandan law and which does not have enforcement in Kenya. So we need to have a uniform framework if we are going to ensure that human rights violations emanating from corporate actions are mitigated.
Thank you very much, Andrew Biaruhanga. I think this is the last word. Thank you to all of you and audience. Sorry, I have not been able to take all the questions, but I guess the conversation is keep going on. Again, business is important, but ethics is more important. Gender issue is important. Environmental issues are important. If you want to change this continent, we have to make all this happen all together. And to come back to your question, we need also local champions, African multinational, to tackle those issues I've been mentioning. Thank you very much. I've been pleased and honored to moderate this panel. Thank you.